I'm KRusso of the Wrongful Death and Injury Institute. In our ongoing effort to explain to you families how important it is for you to know what you can and should be doing if you have a loved one locked up in a jail or prison, I want to highlight a case out of Tennessee that was the equivalent of a perfect storm for us, of every trick and trap thrown in front of a family by a prison system to deny them information and access to a dying loved one. But before I get into the details of this case, let me say that most families are not prepared to handle any healthcare and death issues dealing with the correctional system. They're not prepared because they're not knowledgeable, and they're not knowledgeable because they rely on everybody else for the information they should be obtaining through reputable sources. But even when they do obtain this information, they have the added problem of not knowing what to do with it. We want our clients, the families, knowledgeable of the system they're forced to deal with, whether that system is the correctional or medical system, medical examiner or coroner system, or funeral industry. And we want them to learn what to do, how to do it, and when to do it. Again, this is one of the key reasons the Institute exists. So let me start by saying that if you have a loved one going into the system, or if they're already in the system, you must have in place key medical documents for the benefit of that inmate and yourself. And by key medical documents, I do not mean documents that are given to the inmate by prison personnel to fill out and hand back to medical personnel. And I do not mean documents pulled off the internet. Both are substandard, insufficient, and not thorough enough for what has to be done for that inmate. The Institute has developed our own key medical documents specific to inmates and their families through LifeCare Interlock. These are proprietary documents that are customized for the inmate, his specific medical needs, and the family. Along with those documents, we provide detailed instruction on how they are to be utilized. You can get more information about them at www.lifecareinterlock.com. The bottom line is this: without these documents in place, you're not going to be able to aggressively advocate for the inmate about any healthcare issue or problem he or she may have. You're not going to be given any information from medical or correctional staff. You're not going to be allowed to access that inmate's medical records, and most likely, you're never going to be called by the prison or hospital for authorization to remove that inmate off of life support or a ventilator, and the list goes on and on. So, LifeCare Interlock documents are an absolute requirement. Now on to the Tennessee case. First of all, I'm not sharing the actual names of any of those that were involved. The inmate I'm going to refer to as John Q. His brother I'm going to refer to as Sam. This is going to be a two-part video because of the complexity of the issues in this case. My goal today is to relay to you tricks, traps, and tactics that a system can and will attempt to use on you to keep you away from a sick and dying inmate loved one. What happened in Tennessee happens in every state, every day. I have talked and written about this for over 20 years. Said another way, I want you to take what I'm saying today and realize that it's happening in your state right now, wherever you are, and it can happen to you at any time without warning. The Tennessee case was riddled with problems of bad health care to no health care, which morphed into undue suffering and ultimately death. Within those problems, additionally, what had to be dealt with was the arrogant, unprofessional behavior of DOC administrators, the deceit and lies put forth by the medical director, correctional and medical staff, the chaplain, and the medical examiner's office, all of which was followed by the unethical behavior of lawyers the family consulted with subsequent to the inmate's death. Like I said, a perfect storm. John Q. was in a state prison. He had a history of heart problems, but those problems were handled and kept under control with medications he was taking. He had no other health history. Sam visited him often on a regular basis. He was able to walk on his own, speak well, and was keenly alert. Then, on one particular visit, John Q. was wheeled out to the visiting room in a wheelchair. Battered and bruised, with stitches over parts of his head and face, he told his brother, "I'm like this all over. I was on my way to get my meds, and I was walking along, and the next thing I remember, I had all of these injuries." Subsequent to that visit, Sam called the prison to ask about his condition and to tell the medical staff that John Q. needed some medical attention immediately. They said they couldn't talk to him about his condition, but they would look into it. It was clear at the next visit, 1 week later, they had done nothing. He still had to be wheeled out in a wheelchair, and while he looked only slightly better, he had a new bruise on his face and neck. And there was clearly another medical problem which manifested itself. John Q's speech had changed. There was a marked difference in his ability to communicate with Sam. His words were garbled, his sentences were fragmented, and his attention span was grossly impaired. Sam called the medical unit again and demanded that they get him some help. He explained to them that it was obvious to him, as it would be to anybody, that John Q obviously had a head injury that they're not treating, and it's getting worse with each passing day. Medical staff again tells him they'll look into it. Sam later finds out from other inmates that contacted him that they, the inmates, have to get John Q dressed every day because he's unable to do it himself. Despite even the request by those inmates to medical staff to get John Q help, all of their requests were ignored. When the medical director later told Sam that John Q was getting the best of care, Sam argued aggressively, telling the medical director that he couldn't have been getting any care at all because he couldn't fill out the required sick call request to be seen by medical. And if there were no sick call requests on file, then according to the medical unit, in their world, there wasn't anything wrong with John Q. The medical director pushed back even harder and said that would never happen. A nurse would have helped him fill out the request. I am here to tell you families today, and I want you to know that this is a lie. For that to happen, for a nurse to actually do that, the inmate has to fill out a form requesting that a nurse help him fill out a medical request form. If he can't fill out the form requesting his need for help filling out the medical request form, then he gets no assistance at all. On the flip side, even if he's able to fill out that form, they're not going to make a nurse available for him to do so. Bottom line is this: no medical personnel on their own help inmates fill out any medical request form or any forms to request help with medical request forms. Ever. The only medical form inmates will get help filling out are DNR forms, do not resuscitate order forms. And inmates, for the record, for you families to know, pass it on to the inmate. Inmates should never fill out DNR forms while they're incarcerated, ever. A week later, John Q was sent to another facility that had a hospital. Not knowing any better, Sam shows up at the old hospital, is told of this fact, and unknowingly drives to that facility hospital, asks the front desk for the room number, which they actually gave him. He goes up to his hospital room, opens the door, sees his brother shackled to the bed and completely out of it. He's not even aware that Sam is in the room. Sam tells the CO, the correctional officer, who he is, and that CO quickly tells him he has to leave. He's not supposed to be there, and the CO wants to know how he knew that John Q was even at that facility. Bottom line is, he was kicked out of the room and not allowed to visit. Understand that when inmates, are transferred like that from one facility to another, family members have to get what's called special visit authorizations from the warden, prison doctor, or medical director to be able to see an inmate. There's a skill set involved in getting that special visit authorization approved that I won't go into now, but suffice it to say that when you have a loved one in a prison hospital, a prison infirmary, a TCU, or hospice unit, do not allow any correctional or medical personnel to deny you visitation, ever. I'm not going to go into the ins and outs of how to do that in this video, but if you're faced with that problem right now, contact us. Sam attempts to get visitation authorization from the prison, but no one would call him back. He kept at it. He was then told that John Q had been moved to a hospice unit in yet another facility, and that he doesn't have long to live. Within hours after that call, prison medical calls Sam back, asking him for permission to run a certain test on John Q, but wouldn't tell Sam what that test was. Again, the Institute wants you families to know that when you get a call like this requesting your permission to have a certain test performed on the inmate, and you're not told what those tests are, you must demand the answer be given to you and the reasons for the test before you even give them permission. Now, there are 3 reasons why the system would even call you in the first place, asking for your permission. One is that the inmate is not able to give permission for the test himself. He's either in a coma or so sick that he can't talk. Another reason is that you may have the life care interlock documents in place, which require medical staffers to call you and ask you for that permission. Another reason is to present a facade of actually performing some kind of health care test and treatment without ever doing it. Another reason is to set you up, to tell you that the inmate has died, either before the test was ever done, or shortly after the test was supposedly done, or while you were on your way for that last visit. There have been inmates who have been dead for days, and the system never told the families of that fact, while all the while the families are trying to make airline reservations and hotel arrangements for that last visit. Sam demands visitation, but the system still pushes back and cites HIPAA laws. They explain to him that authorization has to come from the prison doctor. Arguments prison doctors give will always be that it's not in the best interest for the inmate for you, the family member, to visit him. And I'm here to tell you, families, again, do not lay down for this explanation. Do not accept it. It's not a valid argument, and it must be challenged immediately. If you're told this, I want you to know that there is a way to get that visitation. Do not back off. Do not buy into what you're being told, and do not back down. As Sam explained to us, they know he's dying, but they keep the family away. They cite HIPAA laws and any other tactic they can throw at you to shut you down and keep you away. But then at the same time, they start sharing sensitive medical information with you over the phone. The very information they refused to give you when they cited it was HIPAA laws that prevented them from talking to you in the first place. In part 2 of this video, we'll be talking about the death of John Q., the lies that were told to the family by the medical director, the contract specialist, and chaplain, if you can believe it, and the unbelievable time it took to finally get an autopsy performed on John Q. Visit our website for more information at www.wrongfuldeathinstitute.com. Until next time, thanks ever so much for tuning in. We hope it helped.